Now, we had some spirited discussion about The Voice last night with Liz and Justin and Amanda Stoker too. Long may it be the case. People have got to be able to freely disagree with The Voice. But I'm not going to continue to sit by quietly while others try to frighten the nation, telling us The Voice will upend the very way this country is governed. And last night, Amanda Stoker joined with those who suggest The Voice provisions will clog up all kinds of government actions with legal action through the courts.
What that means is that if they don't take into account adequately and give the appropriate weight in the circumstances to what that body has said, in the judgment of an external lawyer looking at it later, who wasn't a part of the decision-making process, then that decision can be set aside, sent back to be redone.
Yeah, the thing is, of course, there could be legal action. There always is with any changes, any legislation, any laws. As I said to Amanda, it's a huge leap to suggest, though, that this will lead to major strife. I mean, there are legal cases running against government decisions in our courts all day, every day, right across the country. The question is not whether The Voice would be any different, but whether there is any serious risk to governance here. Former High Court Chief Justice Robert French has addressed this, saying you can't say the risk of court challenges is non-existent, but that if it eventuated, it might mean that sometimes ministers might have to consider representations before making decisions. And he points out that is a far cry from being required to comply with any advice in those representations. So there you have it. The worst outcome you could get from the courts is a decision that says you've got to listen to The Voice before you take a decision, which could easily then, of course, ignore The Voice. And even that obligation is unlikely in the minds of these legal experts. This is reflected too in the official advice of the Solicitor General, Stephen Donoghue. He says The Voice's function of making representations will not fetter or impede the existing powers of government. And he points out it would not impose any obligations on government to follow any representations or to even consult The Voice before making decisions. So there you go. That's as senior as you can get in legal advice. Take a chill pill. I caught up with one of the 6 senior lawyers, former heads of national lawyers groups, who issued an open letter yesterday endorsing The Voice. Matt Collins, KC, explains why he and his colleagues decided they needed to join the debate in support of The Voice.
Look, we're speaking on our own behalves, Chris, from the perspective of people who we think we can make a real contribution to this debate. You know, with COVID, the experts were the epidemiologists. We reckon with the referendum, one legitimate group of experts are lawyers, because we do have experience in how legislation is interpreted, how our constitution operates, how our courts operate, and how our parliament operates. And so we're really motivated by a desire to contribute to a respectful public debate.
Indeed, but just like the pandemic, there are experts and there are experts. There are a lot of debate when it comes to this issue and how it's going to pan out. What do you make of Stuart Wood, the Victorian barrister, yesterday, who claimed that lawyers have a self-interest in supporting The Voice because it'll add to legal complexity, therefore add to their work, they'll get a financial benefit out of it?
I'm just not picking up any of that in the many discussions that I have, Chris. I think actually many lawyers are actually constitutional geeks in a way. You know, we haven't had a constitutional referendum for 25 years. We're throwing ourselves into this because we find it interesting. You know, the question we're being asked to decide is an important one. And it's structural and it's legal at its base. So it's absolutely front and centre, I think, the responsibility of lawyers to assist in informing the public about the issues.
Yeah, he also says that lawyers, that governments are such big clients for lawyers. 50% of the work through the courts, that barristers chase has got some sort of link to government. So he's suggesting that lawyers want to appeal to the Labor government in Victoria and Labor government federally. Do you detect there's any merit in that argument?
I don't think so, Chris. Governments come and go. You know, some of the people who are the most eminent proponents of The Voice from my profession are people like retired High Court judges. You know, it can't really be suggested that they're doing it in the hope of getting the taxpayer's dollar. You know, constitutional academics like Anne Toomey, you can't say that. the Solicitor General, who's given a very reasoned, detailed advice about how he says the constitutional amendment would operate if passed. His motives are beyond reproach, and I hope people would think the same about those of us who signed the statement yesterday.
Yeah, I've read your letter. You talk about how it's constitutionally safe and that it actually enhances democracy rather than undermines it. But as you say, there's different opinions. On my program last night, Amanda Stoker, the former Assistant Attorney General, lent weight to these claims that legal action under the voice could tie up government, could slow down and interfere with all sorts of government decisions, when the Solicitor General's advice says that won't be the case. The former Chief Justice of the High Court, Robert French, says that won't be the case. Tell me why her argument is wrong.
Because what we're being asked to do is to give a power to the federal government. To the federal parliament. It'll then be for the federal parliament to put meat on the bones of that power. It's exactly the same as the many other powers in the Constitution. We gave the federal parliament power at the time of federation to make laws about all sorts of things, from post and telecommunication services to defence to foreign affairs. And now we leave it to parliaments from time to time to put meat on the bones by passing laws in pursuance of those powers. And we trust in the democratic process that if parliaments are seen by the people to have exceeded their powers or to have acted wrongly, we vote them out at the next election and there's a chance to recalibrate the laws. To my mind, that's what we're being asked to do this time. We're being asked to give a power to the federal parliament that it doesn't currently have. We'll then trust parliaments to pass laws and to change laws as circumstances change to define how the voice would operate in practice.
And look, there'll be legal challenges. There always are legal challenges to laws and certainly changes to the Constitution. But if a challenge were to suggest that a government hadn't listened to the voice, then the most a court could do surely would say that the government should just listen to the voice, not take its advice, not enact that advice, but just listen to it.
And that would be the worst, I don't mean the worst case scenario in the sense of a policy outcome. It might be the best case scenario to require a member of the executive to listen to a bona fide representation that had been made by the voice. But the obligation would ultimately be informed by the content of the legislation. And if the legislation said that a particular matter had to be taken into account in a particular context, then it would have to be taken into account. In the same way that, for example, the Minister for Immigration has to take into account all sorts of matters when determining visa applications, and examples go on and on. But equally, it would be open to the Parliament to define the circumstances in which representations from the voice had to be taken into account and how.
So is there a lot of scaremongering going on?
You could characterise it as scaremongering. I think it is right for us to be debating the potential pitfalls of the question that we're being asked to decide upon. My point, and the point of those of us who I think have come conscientiously to this view, is that if you think there's historical injustice which is deserving of redress, if you think there's a gap that needs to be closed, this is a bona fide proposal which stands very good prospects of helping us to improve the lot of our Indigenous brothers and sisters.
Matt Collins, thanks so much for joining us.
It's a pleasure.